Yachts and boats, commercial marine, high-performance boats. Yep, we've gone boating. Arrowhead Marine Insurance, available coast to coast.
Michael Klausner, professor of business and law at Stanford Law School, has collected data on securities actions, including how many actually are dismissed and how many are settled. Also, if there is a settlement, who pays for it? In this interview with Insurance Journal's Annie Simpson at this year's Professional Liability Underwriting Society's D&O Conference, Klausner answers these questions.
Between 30 and 40%. And that's been a long-term trend. Maybe there's evidence that it's increasing a little bit, but again, I'm going to wait 5 years before I announce a trend. But the range is 30 to 40% dismissal plus voluntary drops. And often the voluntary drops are after a dismissal without prejudice, so what they are plaintiffs that choose not to refile complaints. That's one of the areas that I have collected data on, and I'll tell you it's very hard data to collect. One needs to look through SEC filings. Sometimes I'm lucky and it's in a court filing, and then sometimes I've got to call lawyers and see if I can coax it out of them. So, of course, there are three parties that could be paying. There's the insurer, there's the company itself, and then there are human beings involved. So human beings very rarely pay. If you divide the human beings into officers and directors, directors, and this is an area that I've done research in, the way I got into this area of research, directors pay very, very rarely. A small fraction of 1% of cases result in an outside director paying money out of his or her own pocket. Officers pay more often. That comes to about 5% of cases. And then the vast bulk of cases are paid by the D&O insurer and the company. Now, if you take that set of cases, in 2011, 65% of cases of settlements had the insurer pay 100%. About 18% of cases had the insurer pay nothing. Now that could be, that would include small settlements that are under the retention, and they would include cases in which the limits were used up through parallel derivative litigation, perhaps criminal litigation, and it would include cases where the carrier successfully denied coverage because of an exclusion in the policy. So in between that 18% and the 65% is 17%, if I've got my math right. Those are cases in which the insurer and the company shared the payment. If we'd looked at the distribution of those, they tend toward 100%. They're at the higher level, and I think what that generally reflects is, again, limits in hitting limits in coverage, retentions, and perhaps compromising the payment because there is arguably an exclusion involved.